Good afternoon, everyone. Welcome to our final webinar for taking care of your financial health for 2021. We're excited to see you or to have you online. I miss seeing you in person, but we hope to be able to do that again in 2022. So get vaccinated, everybody, so we can get over past this COVID issue and enjoy meeting together again in person. We're coming to you today from the auditorium in the West Tower on the Torrance Memorial campus. Our presenters are here with me, and we're speaking to an empty room and the cameras. So we're hoping you will learn a lot today, and we enjoy being able to present this information. I want to give a shout out to Mitch O'Yee, who's in our media services booth. He's taken care of all the technology, and my colleague Margaret from the Foundation office will be collecting all your questions if you call in or if you submit them in chat. So I'm Sandy Vandenberg. I haven't introduced myself yet. So I'm Sandy Vandenberg, Director of Plan Giving in the Foundation office, and I am pleased to be able to partner with our Professional Advisory Council members to bring you this series called Taking Care of Your Financial Health. Our Professional Advisory Council is a group of volunteer estate planning attorneys, CPAs, financial planners, professional fiduciaries who are dedicated to supporting Torrance Memorial and also to educating the community about charitable and tax planning and the ways that you can make sure you take care of your financial health as well as what the hospital does for your physical health. So we posted, actually yesterday I emailed everyone who had RSVP'd with a handout for the PowerPoint today and a couple other additional handouts that Ron wanted everyone to have. So hopefully you received that. They are on our website at torrancememorial.org/events. Click on financial health on the left, and that'll take you to where you can get the information that's available online right now too. So I'm also happy to send that to you afterwards. If you would like it mailed, then please, you can enter in the chat or you can email me directly and I will send you a hard copy. We are going to hold all the questions until the end. So use the chat feature is on the bottom of your screen to submit your questions throughout the presentation, or you can call 310-784-4843 and Margaret will pick up the phone and she will document your question and we'll try to get to as many of those as possible at the end of the presentation. You control how you see your the screen yourself. So in the upper right corner, you can see there's a gallery view or a speaker view. So you can control that and look at, if you change it to speaker view, you'll see the PowerPoint and the speaker's face in the corner of the screen. I have my laptop on over there and it's echoing because I forgot to turn the sound down. So I'll do that pretty soon. It's distracting me a little bit. We will be recording this webinar and it will be posted on our website sometime next week. I will email everyone who has RSVP'd so you will be able to know when that is posted and can share it with others or watch it again if you want to learn some more. Many of our events are being done via Zoom this year, and Miracle of Living is our health lecture that has typically happened on the third Wednesday of the month. We have another one coming up on October 28. It's actually a Thursday evening via Zoom, and the topic will be diabetes. Another thing that's coming up for many of you is the open enrollment period for Medicare. And our Torrance Memorial IPA group has a lot of great resources on their website for Medicare questions. So you can find that at torrancememorialipa.org. And if you search Medicare, a lot of things will come up there and it can help walk you through that process. So I always like to give some kind of a highlight of what's going on at Torrance Memorial. And many of you are familiar with our holiday festival. We set up that big tent in the parking lot on Sky Park. And we fill it with beautifully decorated Christmas trees, have a boutique with lots of different kinds of holiday gifts to buy and things that help to kick off the holiday season. Our plan, last year we did it all virtually and we weren't able to gather. This year we are moving forward with setting up the tent. There are a lot of questions yet about how that's going to work, how many people we can have come through the tent, and how all the details of that are still being worked out. But you can look for that. November 30 through December 5 are the dates the tent will be in the parking lot and open to the public. We also have an opportunity drawing again for a Toyota Camry, a 2022 Camry XSE. It's a brand new model. So you can visit our website and get the phone number. You can't purchase those tickets online, but we're in the process of also doing a mailing to get those opportunity tickets out there. So it's watch for more details on how this is all going to work this year. We really miss having everybody in person, and so we do hope to do that. I mentioned I'm director of plan giving, and plan giving is the kind of future plan you make for what's going to happen with your estate. And there are lots of different ways to do that. A bequest is the most common. And you include Torrance Memorial in your will or your trust as a beneficiary, and leave us a gift after you're gone to help continue to provide great health care in our community. Torrance Memorial is a nonprofit hospital, and so we do depend a lot on the donations of the community to help provide the excellent care we do to make sure that we can cover all those who are uninsured and so on. There are also some great options with plan giving to generate income for you. The gift annuity, the charitable remainder trust, those are all really great ways to avoid some capital gains tax with current assets you have that are highly appreciated, and also generate an income stream for you for the rest of your lives. So those are just a few of the things that are important. I wanted to highlight this IRA charitable rollover, also known as the qualified charitable distribution. For those of you who have not yet taken your required minimum distribution, your RMD this year, this is a great way to support charity and to help avoid some income tax. So you can donate up to $100,000 from your IRA if you're 70 and a half years of age. It qualifies as your RMD, and that amount does not get added to your adjusted gross income on your tax return. So that AGI is used for a lot of other calculations. So this is really a great way to support your favorite charity, and which we all hope is Torrance Memorial, and also qualify for your RMD and take care of that as well. And because we consider an IRA as part of your estate plan, anyone who does the qualified charitable distribution is also welcome to our Heritage Society. And the Heritage Society is a group of those people who have included us in their estate plan, and we like to recognize them for their visionary support for future. We have a really excellent plan giving website that gives you a lot of great information. There are I mentioned those income generating tools for the annuities, the charitable remainder trust. There's a calculator there. You can plug in some things and you can see what that would mean for you for tax savings, what kind of income you can get. And there's also this excellent estate planning kit you can download from that website. It is a place for you to keep record of everything in your estate. So all of your bank accounts, your family members, your pets, everything that someone will have to find after you're gone. And so Grace and Ron will be talking about some of the challenges with that. So this is a tool that really helps to bring that all together in one place. My email address and phone number is listed there. Please don't hesitate to call if you have any questions. I'm happy to talk through whatever is going on, or help connect you with one of our professional advisory council members also. We also have some financial health articles there. And then I just want to include how to donate to Torrance Memorial so that we are, you can help support the great work we're doing in the community. So I am going now to turn it over to one of the co-chairs. We have co-chairs here for the Professional Advisory Council. Grace St. Clair is one of them, and she is presenting today, so you'll hear more about her in a few minutes. And Chris Cordova is one of our certified financial planners who is going to be coming to us remotely from his home office. and I hope he's queued up to do that. But Christian Cordoba is a certified financial planner, as I mentioned, and he's founder of California Retirement Advisors located in El Segundo. He specializes in retirement planning, 401k, and IRA preservation strategies. So hopefully we're going to get Chris up on the screen and he will introduce our speakers.
Hi, everybody. Sandy, hello, and thank you as always for everything you do. Welcome to everybody else on behalf of the PAC. And I'll just begin quickly by covering the ever desired disclosures. How about that? So it's important for you to know that this material is for general information only and not intended to provide specific advice or recommendations for any individual. To determine what's appropriate for you, of course, please consult with your qualified professionals. Today's presentation is entitled Boot Camp for the Executor. And of course, due to life uncertainties, plus the fact that we're on the brink of the 20th anniversary of 9/11, I can't think of a better time for this topic. So today I have the privilege of introducing our two speakers, two extremely knowledgeable professionals, as you'll see, and also really nice people. Ron Miller is a licensed professional fiduciary, a national certified guardian. He's also CEO of Select Fiduciary Group, and he has 30 years now of corporate trust and private professional fiduciary experience. He has managed over 500 trusts, estates, probates, and conservatorships, daily money management, and receivership engagements involving liquid assets, personal property, insurance, retirement plans, marketable securities, residential and commercial real estate, alternative assets, and family business and related liabilities. That's a lot, Ron. His experience doesn't stop there, though. It includes portfolio and property management, corporate finance, business management consulting, fiduciary and corporate governance, real estate consulting, conflict resolution, and litigation support. Ron, thanks for all you do, and thanks for being here. Then you'll have the privilege of listening to Grace Greer St. Clair. And Grace is an independent attorney whose office is located here locally in Redondo Beach. Her major area of practice is estate planning, and her additional legal expertise is in real estate, general corporate, and financial transactions, which allows her to also support the businesses of her clients. Grace began her career working with a large law firm in downtown LA, which allows her to handle client matters with a large firm commitment to excellence and a small firm commitment to personal service. Nice combination there. She endeavors to support local charities while serving her estate planning clients, which she's doing today, providing them access to the local charitable endeavors and support their passions and creating family foundations. Great causes. She is also an artist and began oil painting as a child. Her artistic talents add to her breadth of experience and enhance her practice as an attorney. I'd love to see some of that art someday, Grace, but thank you as well for being here. And at this point, I'll turn it over to you, Ron. Thank you all.
Thank you, Chris, for that kind introduction for both of us. Just want to open saying just one thing. First off, for anybody out there with 9/11, it's a solemn day for us because my family members, we lost two people in 9/11. So this is a day that we think about. The second, I want to say that on behalf of Torrance Memorial and the PAC, we really are looking forward to the opportunity when we can next see you in person. We miss seeing you folks and always look forward to it. It makes it always a much more engaging presentation for us. I want to talk about just some of the situations. So for example, my own family had an issue. My father-in-law a week ago fell, he had a massive stroke, hit his head, massive bleeding. We were on death watch for all this week and a half, and he finally came out of it the night before last. So some of the stuff that we talk about, these issues, they are things that affect us as professionals as well. So we understand how these things affect you folks as well. The first thing I want to do is sort of frame the understanding of who the players are in a probate situation. We have probate, which is a court supervised process for administering a will. It's also a process for dealing with other kinds of situations that might come up in the administration of a trust or conservatorship or whatever. But we're talking about probate for the estates right now. The decedent is the person who has died. The executor or executrix is the person named in a will to administer the will. Oh, thank you. Sorry about that, folks. The personal representatives, same thing. Administrator is the person that's appointed by the court to do the same. Trustee is the person who administers the trust if you have a trust in place. In wills, most of the attorneys in California now draft what we call pour-over wills. And the intention of that is anything that wasn't named to be a trust asset is going to be deemed to be a trust asset. It makes the administration more efficient. It reduces the likelihood that you'll need to be in probate and avoid the costs of probate generally. Fiduciary is just a technical name for the person that's serving as that administrator, executor, trustee, et cetera. First off, we want to try and eliminate some of the things that you would have to think about in probate to begin with. And the kind of assets that usually avoid probate are things that are processes where it's designed to go to a beneficiary. So a pay on death bank account, transfer on death accounts, those kind of things, insurance policies where they name a designated beneficiary, retirement plans, et cetera, trust assets, gifts that were designed to not to avoid creditor claims. We don't have those kind of creditor claim trusts, so gifts that avoid them are good. Joint owned assets, so your bank accounts that have the husband and wife on them, for example, or the spouses. When the first one passes, those will transfer to the surviving spouse. And then small estates. We'll talk about that in a moment. There are some reasons why you need to have probate, some situations where it's going to happen. Generally, there's a process for creating a will. I won't go into that because I'm not an attorney. Grace can speak to that. But generally, the process is very structured. And so the traditional thought that most people have about a will is that situation where you write it out in your handwriting. I'm of sound mind, blah, blah, blah. You get a couple of witnesses to sign, and that's what we call a holographic will. Whether the will is holographic or not, if it's handwritten, it's probably going to have to be probated. Personal property that didn't get into the will. There are some situations where people didn't think to include things. Assets, again, tenants in common is a similar to a joint survivor case. Assets that are in the name of the decedent. So if mom has a bank account and it's in her name, and let's say that even she had a trust, if the bank account is in her name, that's a will asset, not a trust asset, unless it's dealing with a pour-over will. You also may have situations, title disputes. These come up all the time, and it's not necessarily a dispute. It could be an ambiguity or a mistake in the title documents. If you don't have any beneficiaries, or if your beneficiaries are predeceased, if you have children and they died before you die and you don't have other beneficiaries. We talked about ambiguity, scrivener's errors, things that are not clear. A trust or will contest, any kind of contest is going to go to the probate if it can't get resolved otherwise. And then I mentioned this issue of the small estate. The amount is $166,250. If you're at that amount or less, you have what's called a small estate, and we have a form called a 13100-13100 small estate affidavit you can fill out. We have a picture of that in a moment. If the decedent was involved in contracts, let's say that they were in the process of selling real property, the contract has already been executed, they pass away before it's completed, that's going to end up having to be dealt with as a contract in probate. Complex assets, businesses, royalties, copyrights, patents, any other kind of IP. The insolvent estate. So one of my stories is going to be about an insolvent estate, and you'll see how that affects it. The assets in foreign jurisdictions, the word foreign here means something outside of California, or in the case of a county asset, something outside of LA County for those of us in LA County. And then property that's given to a minor, in particular real property, cannot go directly to a minor. You'd usually have to set up a custodial account or a guardianship for that. So we want to talk about if you have assets and whether you have a will or not, whether you have a trust or not, what that looks like. So when you're alive, the assets that are in your name, they're owned by you. If they're in a trust that you created and they're titled in that trust, then it's a trust asset. When you die, the assets that were owned by you individually are now owned by your estate if they weren't transferable to your trust. If they're in the name of the trust, they will still be owned in the name of the trust. If you owned an asset that has a beneficiary designation, such as a retirement plan or insurance policy, those will be owned by you. They will go to the designated beneficiaries. And generally in that process, the administrator, the executor of the will, they simply inform the financial institution by providing the death certificate, and they might have to sign one or two other documents. And then the financial institution takes over. It doesn't become the responsibility of that fiduciary to handle. So when you have no will and you have no trust, this is what we call intestate. Anything less than the 166,250 or less, that can go under that small estate affidavit, and you don't have to have a probate. It follows the intestacy laws of California. If you have assets over the 166,250, that's going to be in a probate. And the court will assign an administrator if an executor wasn't already nominated and available and willing to serve. If you have a will but you have no trust, the will would have named an executor, presuming that executor is alive and willing to serve. Again, we've got that small estate affidavit situation. But if you have assets over that, and again, you're going to have a probate and that administrator or executor is going to handle it. If you have a will and a trust, which is the ideal situation, you don't really have to worry about most of this. The executor handles the will side if there is a will side to handle. If it was a pour over will, it's basically going to be the trustee handling everything. Now, we gave you some handouts, and in there we've got several documents that come from LA Superior Court, which are really good guidance on what we would call the process, the steps you need to take in a probate. And this would be a simple probate. You'll discover pretty soon that there are very few simple probate estates. But if you have that, you can go through those steps and you would serve as what they call a pro per se. So you represent yourself. You could do most of all that work. But I will tell you, as an experienced fiduciary, there's a great deal of legal stuff that needs to be done. Most of it is beyond the scope of what even professional fiduciaries would typically handle. So in the more likely circumstance, this is to just inform you of the kind of things that they're going to be getting done. And probably your attorney is going to be predominantly the person helping you to get that done. But generally, just the first pass is you need to get death certificates. And you need to find out where the will is. That will has to be submitted to the court if there's going to be a probate. And you have to figure out who's going to be in charge as the executor or administrator. You need to get the tax ID number, the EIN for the estate once you die. It's no longer your individual your Social Security number. It's an EIN from the estate that needs to be used. You have to figure out who the parties are, who are the heirs and beneficiaries, and then determine what other assets are out there. And one of the first steps is to collect all the mail, email, all the kind of documents. You also need to turn off credit cards. You need to notify various government agencies. For example, many people have Social Security the last month in which you die. Often you die at a date when you've got a payment, and that payment is going to have to get returned. Bank accounts, gathering all of the information, insurance proceeds we mentioned, Social Security tax returns, that's a big one. Usually that's going to be toward the end of the probate process once you've gathered all the information and you've got an understanding of what your assets and liabilities are. So we talked about checking various different sources for information. The financial statements referring to your tax returns, if you have a business entity, those financial statements. In California, the state controller has a website. If there are unclaimed assets that have been escheated, you can go to that website and you can actually collect those yourself or on behalf of the decedent. When we go into a property that was owned by a decedent, we always do a visual inspection and document the condition of the property and any items we find in it. Sometimes
take that
checks to see if there's anything else out there that we don't know about in terms of debt and liabilities. And of course, we're going to review those tax returns because they're a wealth of information. I'm not going to go through this in detail. You folks can read this as well as I can, but generally speaking, think of all the different kinds of assets and liabilities that you might have in an estate: bank accounts, investment accounts, insurance, real property, personal property like cars and jewelry and art and collectibles and those kind of things. We also have a significant amount of liabilities that folks need to think about. So the first one is obviously person dies is going to have to get buried or cremated or otherwise disposed. And so those kind of expenses are very common. I've mentioned the credit cards, turn off the utilities if the person's not living there, nobody else is living there. Social Security overpayment I mentioned. Medical recovery we'll talk about in a moment. Mortgages on the property. When you resolve an estate, you still have to pay off a mortgage generally. And then of course, sometimes as part of an estate plan, a person will create things like promissory notes, or there might be taxes outstanding, and there are a wide variety of them, business debts, et cetera. This is your form 13100, the 13100 we mentioned, the small estate affidavit. If you have an estate that is 166,250 or less, you can use this, and then you don't have to go through probate generally. We talked about the steps for simple probate. So when you go through those handouts, you'll see that they've done a very good job of listing those steps that would need to be taken. I will make the note, as I made before, the steps that are on this slide are almost all done by an attorney, generally speaking. There's things that you can do, but most of it's going to require legal expertise or an understanding of the legal elements that are involved in the case. This diagram is a chronological layout of the actions you take, both in terms of the documents and in terms of the petitions that are filed. I'm not going to go through that. Generally speaking, with real property, it's a little bit different. You have to be careful about it because titling of it is important. You want to make sure it's protected and preserved. The primary duty of a probate executor or administrator is to protect and preserve assets, not to grow them or otherwise use them. And as a part of that, we have something called a preliminary change of ownership. We'll talk about that in a moment. But the idea of this is there are a number of different statutes in California that allow you to restrict, by use of them, to restrict any reassessment of property taxes. This all changed dramatically in February 15th, 2021, when Prop 13 elements became effective. It's a very complex process. If you have that, you probably need to talk to an attorney. It's so complex that we probably couldn't have put it on a slide, and it wouldn't have made any sense if we did. Prop 19. Yeah. Is that what I said? No. 13. Sorry. Prop 19. Okay. We mentioned the Medi-Cal clawback. The primary point I want to make about the Medi-Cal clawback is be careful not to have any of your family members, friends, whatever, sign as co-signers if you didn't intend them to be responsible for that clawback. The idea of the clawback is if you, in the last few years of your life, needed Medi-Cal services, those services have to be reimbursed upon death unless certain requirements are met, in particular having assets in trust, having assets that are protected, and so on. So one of the key steps that is involved for the administrator or executor is what they call the inventory and appraisal. That is your first pass to inform the court of what is in this estate, both in terms of assets and liabilities. There's some forms you have. I want to be clear that the only part of appraising that's done with these assets by you is when you're talking about cash assets. So all other assets that are non-cash are handled by a person called a probate referee. It's the same as an appraiser. We've got mentioned a little bit about that inventory and appraisal. I've got a picture of what one looks like. And then we also have, toward the end of an administration, what's called an accounting. So the judge is going to want to see that you've done all of the things that are supposed to be done by you as the executor administrator. And they want to know where all the money has gone, where the money has come from, anything that is left over and who it's supposed to go to. That's what these accountings are for. They're also a way of proving you did what you were supposed to do. And when the judge eventually approves them, they then will allow you to terminate your role as the administrator. There are quite a few different kinds of notifications that take place. This is something that almost always is handled by the attorneys because there are different kinds of notices. There are different timings of notices. These notices are critical to get the process started. It's critical for certain periods to expire before you can start doing things. And then there are notices whenever you need to take action. You have to file petitions later if you're looking to exit the case because you've completed your work. All of those have different notice requirements. In California, compensation to the executor administrator and their attorney is what they call a statutory fee. And I won't go through it in detail. You can see what it is. Gives you some examples of, depending on the size of the estate, how much that compensation is going to be both to the administrator, executor, and the attorney. I'm now going to turn this over to Grace. Oh, yes, I'm going to tell my war story. I'm sorry. I will tell my war stories. So let me just set the framework for it. This is probably one of the most complicated probates that anybody has seen in the state in a very long time. So I'm not going to go through it in excessive detail. But the background is it was a person who did not have an estate plan. So again, back to my first statement in the presentation, get an estate plan done by a competent trust and estate attorney. This person didn't do it. They used their accountant, their personal accountant, to do to creation of family businesses and setting up the accounts. It was underfunding the accounts and under capitalizing the businesses. The person died in a helicopter crash with 3 other people involved. 2 died in addition and 1 survived. So we have lots of issues with wrongful death claims and what they call loss of consortium for the person who survived, long-term care requirements, and so on. Fast forward, this case became very complex because all of these businesses, which were funded by debt and were not well organized, were also not well record kept. And so we are now 2.5 years into this administration, and we're still working to shut down these business entities, to distribute assets for them, to sell assets that will monetize the estate that we'll use then to administer it. Obviously, with the wrongful deaths, there's insurance. They were underinsured. But again, this case goes on, and there are lots of issues that all circle back to the original point of having an estate plan in place. If this person had that, they wouldn't have had a probate to begin with in most cases. For the businesses, they would have just had people appointed to administer them and to close them out. And then those monies would have been distributed to the estate, and the estate would be moving forward. It's also what is known as an illiquid estate. There were not enough funds. There were very few funds in cash. So all of the creditor claims, both at the business level and at the estate level, far exceed the amount of funds in there. So we're in the process of mediation and negotiations trying to resolve those. This estate will probably last another few years because of the wrongful death claims trying to get resolved unless we can get those out. I'm going to stop it right there, and now I'm going to turn it over to Grace.
I have to apologize. I'm just inserting something here a minute. I was the timekeeper and I only gave Ron 20 minutes instead of 40. So my timekeeping was not very good today. So we'll have lots of time for questions, or Ron may come back and go into more detail on a few other things. So sorry about that.
I can add more stories. Thank you all for coming today. I'm really excited that you're here to learn about this wonderful topic. Sorry you're not here in person, as we've said before, but we're looking forward to that soon. I wanted to start out real quick with a joke. Let me go for don't distribute assets. So even if what Ron explained was a huge process, which is designed to help you get through the probate of a set of assets that a decedent owned. But remember, and this is something that's very, very important, this accounting is a huge, I know you can't really see it in the slide, but this accounting is a huge deal. So even if you've done everything that Ron talked about, you cannot distribute anything until the court approves your accounting. Many people try to give private access to property. They want to give people money out of the bank account. You cannot do that. No quitclaim deeds can be signed, no private access to any of the assets. You have to watch out for that. If you're the executor, you have an obligation to the court and the probate estate to not do things like that. And Ron just explained a little briefly about a business that you have to keep appropriate records. We all know we're supposed to keep great records, but with a business, it's even more important. Many of us don't even view our business as a possible asset that would go through a probate. But if you do not have a corporate formalities handled and someone who could take over for you, suddenly you are going to be in a probate situation. So you're lucky you're involved in that, because there's many issues to be handled by somebody, an adult in the room, shall we say. But those are also very, very important to think about. So the forms here are attached for you just to notice. These are the forms you're going to need. So there's 3 pages of forms there. That should be enough to dissuade you from wanting to go through this process. But it is likely sometimes that we do have probates that occur. So just wanted to go through. So let me do my joke because it affects what I'm going to talk about later. So a wealthy gentleman was terminally ill, and knowing that he didn't have much longer to live, he gathered his 3 closest friends around him, his priest, his doctor, and his estate lawyer. First of all, that's a joke right there. But he told them, I know they say you can't take it with you, but I'd like to try. Here's 1 million cash for each of you. When you walk past my casket at my funeral, please put it in my casket with me. Soon after, the gentleman died, and as he had instructed, as each of his friends passed by his open casket, they dropped an envelope inside. The priest was first to speak. I have a confession to make, he said. I know you can't take it with you, so I gave half of the money to the orphans fund and put the rest in his casket. The doctor then said, I don't think you can take it with you either, so I gave half to the children's hospital, and then I left the rest. Finally, the lawyer looked at his friends in disbelief, shaking his head, couldn't believe what he heard. I can't believe you guys. I gave him a check for the full amount. So there's many questions in this joke that we'll talk about, but was this a loan or was this a gift? When he said, here's $1 million in cash for each of you, did he mean that was a gift? Or was that a loan for them to hold on to? This is how these things happen in normal everyday life. When people say things, a lot of times, if it's not written down appropriately, you won't know, is it a gift or a loan? We'll talk about that in a minute. So I just wanted to go over a couple of my horror stories. So hold on, let me get my notes. Here they are. So first of all, I have some cases recently in the office which are somewhat unbelievable, but happen, I think, on a regular basis. The relationships that we have now in our families, one of the things I wanted to note about probate is the code is set up for traditional families. There is no modern family, the quote modern family we see on TV. There is no law that allows a modern family today. Those are unusual circumstances to the state in our state. So one of these gentlemen had 2 girlfriends. Each girlfriend knew of the other. One of them had children with him, and one of those children was a special needs child, and he's 18 years old now. And he has another underage child. Neither one of those spouses, or they're not actually spouses. Neither one of those girlfriends are spouses. So they have no rights to obtain any of his assets. He had no plans. He has children out there that are waiting to be taken care of. Obviously, he was handling these two, I keep calling them wives, these two women's lives. And so now what is the executor supposed to do? How do they treat these people? These two women have children and need support, yet they don't have any right to money. The one special needs child is going to have to get a special needs trust. And the underage minor child is very interesting. If you're named as an executor, you have to know that the minor needs to be notified that she's an heir to his estate. How would you notify that minor? You have to notify that minor personally first, and then you notify the parent involved, the surviving parent. So I think that's something a lot of people don't know. I also had one of my favorite probates, just a simple probate, like Ron explained. Simple probate, just a house. And I ended up when my friend gave this to me, I'm like, oh, okay, simple probate, no problem. Turns out the son was actually disinherited. And so the nephew was supposed to be the executor. The nephew didn't want to be the executor and wanted to resign and replace the disinherited son. So we had to get him appointed as the executor despite his mom disinheriting him. Then going through this process, there was a reverse mortgage on the property. I was working with the bank to let them know what we were doing. Sure enough, the bank decides to foreclose on the property without telling us. This is the only asset for this son that was going to be coming his way. So it was important to him because he was going to use the money to build a business. So he would have something to fall back on as he retired. So I tracked down the bona fide purchaser on LinkedIn, found them, told them we were going to sue sue them to death so that they would freak out. And then I went on vacation out of the country. So I took this case with me and I negotiated with it in my swimsuit at the pool. But the bottom line was we had this all solved and we got him the house back, and the creditor was able to get paid appropriately. Another case I had is 3 children. The brother moves in with dad, spends all of dad's money, borrowed some, which he did actually get a promissory note from his dad, but never paid it back. And then, of course, the 2 kids that don't live in the house have no idea what was going on all this time that dad was there. And they want to know now, what happened to that promissory note? What happened to all the money? So that's another little nightmare story that probably happens all the time. And that's why it's very important to indicate how these people are living in your house when you have people living with you. I think that's probably ideal. Also had a holographic will lately. Sister left a note on a single piece of paper, it kind of something that you tear out of a small notepad. Basically just said she wanted everything to go to her sister. She didn't name an executor. She didn't list any assets. But she did indicate that she wanted her sister to get her property. So we were able to get that handled as a holographic will in court, and everything's going forward with her being the executor and one of the beneficiaries. And luckily, the family didn't fight that. But that's kind of what you'll find is there will be people coming out of the woodwork to fight some of these things. We also have a deed. Now, deeds control your real estate. Interesting deed, community property with right of survivorship for a mother and her son. Now, I know this is California, we can marry anybody, but really, no, it was mother and son, not a marriage at all. It's not community property. So what do you do? The guy can't sell the property because there's a conflict in title. We had to go through, it wouldn't pass a title review at that point. We had to go through a title company to get them all to agree that they could actually consider the affidavit of death between the mother and the son as an appropriate document to make the title go back to the right way. But what happens is kind of like what Ron was saying, the mess always ends up after the fact, and that's what you have to clean up. So it's always better to keep your plans in place. And that's what I'm going to talk about. So the good thing about probate is kind of what Ron was talking about is that you do have an orderly distribution of the estate. It does take forever. because of the orderly distribution, all the forms that you did see. But also, there is an adult in the room and a judge in front of you. The bad thing about that is it does take forever. Cases used to be 24 cases in the morning calendar. Now we have 54 cases in the morning calendar. Everything you're doing is totally public. So all of your family issues will become everyone's knowledge. And I think that's one of the things that's very difficult. When you're grieving and you have issues, it's very hard to stand in front of a group of people as the courts open up and discuss them. And now that you're on Zoom, I suppose you have a little bit of anonymity, but you're still talking about your family issues in front of everybody else. So those are two things that are difficult about probate. But if you do set up a great estate plan and it's updated all the time, you shouldn't have problems like this. So why do we always say that you should update your plans on a regular basis? I know that we all like to put things in the shelf. It's a difficult process. You want to put it on the shelf. You don't want to think about it again, but it is kind of a living being and it does grow with you as your family grows. So it's very important to keep it updated. You do update your medical records every time you go to the doctor. You update your phone number, your email address. If you move, you tell all your friends where you go. So shouldn't you tell your loved ones exactly what you want to have happen over a period of time as things change in your family? I think it's very valuable. The trust expresses what you do want to have happen and what you don't want to have happen. It's even more important now as courts start focusing on our language in these trusts. What I was talking about is the gift and the loan of this little joke. Was that a gift? Was it a loan? How do we know? We are guessing that the gentleman thought, hey, here's some money. Maybe they'll do something with it. Maybe you'll give it to me. We don't know. A lot of times the wording that you put in your trust, you need to make sure that everyone else will understand that. Recently had a case with 11 beneficiaries, 2 of which died either before mom died or after she died. And what had to happen when one of them did not survive her was very difficult to understand what the intent was. So those things are really important. The plans that you put in your trust help you stay in control. You always have the California courts to fall back on. A trust is very similar in process to a probate case, but you don't have to have the judge there unless you need them. You're always, oh, sorry. We're just still talking about war stories. No, I'm kidding. No, let's move on. So we wanted to keep our process updated. So I told you about the traditional family. We talked about, oh my goodness, I'm still on A. I have a lot of things in this. I have a lot of stories here. So the plans put you in control. Again, the courts don't use flexible standards. We have a lot of millennials not getting married now. That's going to be an issue. We have a lot of women who are having children on their own. You have to remember spouses you have to be married to be a spouse to benefit from your husband's trust. Told you about the 2 girlfriends, because those things can change. And that's why you want to keep things updated. Many people leave property out, just like Ron was saying, when you try to find all of the assets. We have digital assets now. We have to watch our digital assets. You need to know how to gather them. A lot of times people cannot get into the computer of their family member because they don't know the password or there's 2-factor authentication. We have a digital assets agreement in our office. We provide this with all of our clients so that they can transfer those digital assets to another party legally without getting into trouble with the terms of services agreements. A little story about that. One of my clients recently passed away and he was subject to undue influence, and the undue influencer tried to come in and steal his phone into the computer. But luckily we had this digital assets account, which allowed them to transfer it directly to the kids because they were the ones that the deceased wanted to have that property. You want to make sure you don't leave deeds out when you get things refinanced. That happens very often. Sometimes we do have one client right now who was married for 6 months before her spouse died. Dated for 23 years, finally got married, but she was on the deed, but she didn't know anything about what was going on in the family. This is very common because people just think, oh, I'll just worry about it later. So that's why it's very important to get these things done right away. And oftentimes people leave out investment accounts. They're very confident about getting the real estate transferred to their trust. They leave out bank accounts. They don't know where the bank accounts are. And that's why it's also very important to keep your assets in an appropriate order. So you want to be clear about your goals also. Do you want your property to be given to your kids at certain ages? Do you want to do something that's more value-based? Should they graduate from college or buy a home? These are the other ways that you can transfer your property. So being careful about who you appoint. This is also very important. The successor trustee of your trust, do they have similar morals to you? That way you'll know if they will act like you would act. We've put in your handouts a special love letter that one of my clients renamed. I called it letter of instructions to the successor trustee. She called it the love letter. And I use that now all the time because it does help my clients indicate to their family what they would want to have happen. If you have young children and your kids are very young, we always want to do a probate avoidance trust. But a lot of times your successor trustee won't know exactly what you want to do with the money and how you want to share it with your kids. They're so young. Of course, you think you're going to take them to all their baseball games and buy things like that, but you don't know the other issues. And that's why it's really helpful to put that love letter together. And then another thing you want to think about is most of the jobs that are required by a successor trustee or an executor are done between the hours of 9 and 5. So the person that handles your affairs has to take time off of work or take time to go to these appointments and reschedule their lives too. So they have to be available and be able to do that. Can they drive to court if they have to go to court? Are they capable of handling things between those hours? Are they so busy that they aren't going to be able to? And then how will you pay for your trustee and your agents? I think this is very important. It's becoming more and more important these days because more and more is required of these trustees. And so you need to be thinking about that. So banks generally get 1% for the assets that they handle, but that's because they handle very large estates that have millions of dollars in them. If you have less than that, you're going to think 1% might not be worth it for your party to do that. It's pretty much a part-time job. So whatever the standard rate for a part-time job would be probably really helpful. They need proper compensation though, because this is a difficult job. So what is required of an executor and a successor trustee? Well, on the one hand, absolutely nothing. Anyone can do this. On the other hand, they have many duties and responsibilities. So you don't need any education to do it. You don't need any, in Ron's case, he has a fiduciary obligation and he probably needs a certain standard of dollars to be involved in his company before he gets appointed. But for most people, it doesn't require any monetary value. So the responsibilities, though, are very great, as you saw earlier, and keeping good records is very important. So you need someone who's very organized. Prerequisites are good at math. Let's hope they can add and subtract. Good at record keeping. Like we told you, many records have to be kept. So it's very important that they can do that. They should be financially stable and strong, able to handle things in a crisis. I think that's the most important thing. Do they have that kind of personality where they can handle issues in an instant and stay calm and be able to not be easily influenced by parties that may or may not be agreeing on things? And who would be a good prospect to serve in your life? That's something for you to think about. And I think the similar moral values is a good habit. But in my case, we had an issue in my family with my sister and brother for various reasons. My husband and I had other feelings about each one of them. And my sister had no children, so that was one of hers. But we chose a friend who was similar to our values. And he was a doctor and we knew his family. He had children in the right area. And he raised his kids the way we were raising ours. So we felt very confident in that, but they ended up getting divorced. And when he remarried, we weren't as big of a fan as his new wife. So we had to think, what are we going to do? My kids were in their late teens and my oldest was in college. And I just felt she was too young to have to take that on by herself. So we named her plus my uncle, who has done it for other people in the past. And I think the two of them, as she grows, would be a great resource. She would have someone to fall back on to help her. So if you don't have someone in your family, though, that you can use, you can consider a private fiduciary for sure. I mean, that's always going to be a good a good choice, and someone else who's a family, not a family member, I guess, and who is willing to do it. But I would definitely make sure that they're willing to handle the issue. So do you have the correct provisions included in your estate plan? Like I was saying, is that a gift or a loan that we just saw in our little joke? Sibling buyouts are big issues now, even with Prop 19. I always call it 21 because it was handled in 2021, but it's actually Prop 19. Many families are still trying to provide sibling buyouts to their children. And that's a very interesting issue. By the time they start buying each other out, they probably aren't speaking to each other. So it's very important that if you could schedule how that was going to happen, that'd be great. I have a case right now where one of my clients is, they have a very small condo in Pismo Beach. And first, nobody wanted it. Then one person wanted it. And then because that one person wanted it, nobody wanted him to have it. And now they're going crazy on this whole thing. And it's almost not even worth going. It's just, I think we should just sell it to someone else now and parcel out the money and call it a day. But those things are still important. Are you interested in sharing retirement plans with your children? That's definitely a new area with the Secure Act. You have to change those things around a little bit now. Why are you interested in sharing that retirement plan now? It's not as valuable anymore. Asset protection features for beneficiaries are very important. Some children have substance abuse issues and need to have their money held in trust. We're also protecting beneficiaries by leaving the property in the trust so that they don't have creditors trying to claim their assets. And also, do you want to protect your siblings, or your kids from spouses if they were to get divorced? Are gifts properly described? That's very important because a lot of times no one understands what you're thinking in your mind at the time. You need to be very clear about that. We have a lazy divorcee situation in my office where he was getting divorced, decided to be his children's friends for 12 years, lived with mom. She paid for everything, including his new wife's teeth redo. And now we spent $80,000 in legal fees because it wasn't really clear in his mind that those were not gifts to him, that he actually had to pay those back. So very interesting situations, which if things were clear, it would be better. And also, who are the beneficiaries? Many times people want to give money to Torrance Memorial, other charities, other beneficiaries, friends of theirs. Maybe you don't have family members that you want to provide your money to, or maybe your family members don't need the money. There are other ways to benefit the beneficiaries and create places where you can benefit others. We're going to have some interesting challenges now with the tax issues. We haven't had a problem with taxes for a long time because the exemption was so high. But now with the new tax legislation, it's very difficult for us to advise anybody because the things are in such a flux. We don't know what's going to happen. So it's likely it's going to come down to 5 million. I think that's probably where it's going to end up. But of course, we just had a conversation with a tax professional on Monday, and he said he never, his crystal ball with taxes has never been a good one. It's always broken apart. So nobody knows. The other thing you want to consider is settling a decedent estate is really very hard, as we've talked about already. There's a lot of reasons to appoint professionals. Even if the professionals can guide you, it's so much easier to know that someone's watching over you when you go to court and telling you what to do instead of you being alone there. The professionals aren't emotionally involved. They aren't grieving. It's a very time-consuming process, and they have the time for that. So cleaning up your affairs now rather than leaving a mess for others later is also very helpful. You want to think about what if someone could find something that you left in your house today when you direct them to go find it in the file cabinet. That's exactly what's going to happen if you're not around. Someone's going to have to figure out where you have everything, where you keep it, what the files, if you have file folders, if the names are still correct. My husband has written over our file folders 5 times. He doesn't want to get out the labeler. So who knows what's in that file? So I know I'm not the only one who does that. Make sure your password protected items are set up through a digital account or someone knows where it would be. I really don't like that because that is illegal, but that is what we have to do sometimes unless we have our digital assets account. What are you leaving for others? Do they know? A lot of times people like to share that in advance. Maybe it's best to do that so people know and they can complain about it early when you're still able to fix that. The funeral versus burial, that's a big issue. Your family won't know what you want unless you tell them. And this happened to us with my mom. She was so worried about my dad, like he never told her what he wanted. So we had to tell my mom it didn't really matter. Whatever she did for him would be good enough for him. And we had a great service because we planned it for him. But luckily, my dad would have liked anything. But if you have a particular person, you should plan something and help people know what you want. Right now, we used to actually have our situations where people, the old, you could be seen and not heard. That was my generation. But we never wanted to tell anyone anything. And we have more litigation now than ever before. So I think it's better to share what you want with your family and come up with solutions. We like mediation if we have challenges with families. I think now it's better. A lot of these things should not be in court. A lot of these stories are embarrassing and frustrating and emotionally charged. So it's always better to work through those things in advance. Having critical conversations. I know it's difficult, but next time you have a nice backyard dinner with your spouse and a glass of wine, maybe it's a good time to have some of those questions or some of those questions answered for each other so you kind of know what to expect. And I think let me make sure I have all my stories. I think that's all my stories. So I think we're ready for questions. Oh, Ron's going to come back for more info.
Thanks, ladies. I actually just wanted to circle back to sort of the beginning of the administration, just talk about a couple of highlight issues. One of the first things that happens when you're deciding whether you're going to be serving is you have to determine whether you can qualify for the bond. In the probate administration, a bond is a form of an insurance policy to ensure that if you did something wrong or if you took money, that the heirs would be made whole and then they would come after you, the bonding company would come after you. The issue with bonding is it's tied to the asset values of the estate. And so there's a formula calculation for it. And one of the first questions that an attorney is going to ask is whether that person thinks they can qualify for bond. Many estates where family members are named or family members want to become appointed, they are unable to qualify for the bond. There's a couple of ways of getting around the bond. Locked accounts is one way, but the other thing that comes up with regard to petitions is you may not be the only one filing. In California, there's a complicated table that draws out the picture of the connections between family members. So think your parents, your grandparents, your children, your grandchildren, your siblings, your cousins, et cetera. As you move outward, these people are further away in relationship. The idea behind this table, it's called the table of consanguinity. Don't ask me what that means, but the idea is the people closest to you are the ones who should have priority of appointment. And so it's very common that it's going to be if you were the decedent, your spouse or your parent, if they were still around, your children or your child, your siblings, et cetera, those people have priority over we professionals. Professional fiduciary is actually at the very bottom of the list, which is, I think, number 31 or something. But all of those people, each of them has a right to petition, and it's very common to see people have competing petitions. And the reasons those issues come up are, for example, family members who are fighting over who should be in charge for whatever reason. Mom wanted me to do that, not you. Dad said that was for me, not you. Those kind of things come up a lot. We have also two different types of authorities that are determined when you make the petition, when you file a petition. The first is what they call full authority. Full authority means that you as the fiduciary, you as the executor or administrator of that estate, you can act without prior court approval. Now, you're still going to have to ultimately answer to the court, but it allows you to do things like pay bills, sell assets, that kind of thing. The limited authority it doesn't allow you to do those kind of things. You have to seek a judge's approval first. So limited authority is not necessarily a bad thing. It comes up when there's no real estate. It really doesn't matter a whole lot. However, this determination whether you're going to petition for full or limited authority and whether you're going to be qualifying for bond or not, it comes up, and you have to figure out what that looks like, because if your petition is filed and not accepted, then you're not going to get the appointment. Also, in the case of competing petitions, it's very common for the judge to decide that neither parties are the right people for whatever reason, usually because they can't agree or that there's going to be conflict in the administration. And they will ask those parties to submit names of 3 other substitutes, and often those are professional fiduciaries on the list. The other thing I wanted to talk about is what happens when you have real estate in a probate. So what usually happens is that you're going to seek what's called court confirmation. It means that you're submitting all of the documents for the sale of the property, and the court's going to decide if that's inappropriate. They're going to compare the value of the purchase price to the value that the probate referee assigned to that real property. And if it's within 90% of what the real property, the probate referee has appraised, then you're probably going to be fine. It's very common that it's not these days because real estate is increased in price so much in such a short time. It's not unusual to have a probate referee valuation that is much lower than 90%. You can go back and see if they want to reassess and see if they might have changed their mind about it, or you might have to do some other things. But once the court confirmation process is underway, you're going to find that there are an enormous amount of people out there who are investors who might want to bid on the property, and they have a process called overbidding. So you file your court confirmation. When the hearing is set and the people show up, you may have an overbidder in the room or multiple overbidders. We've seen in many cases having multiple overbidders. There's formulas for how they determine what the next bidding price needs to be. The court gets to decide how they want to handle the bidding and overbidding process. But the idea is that, generally speaking, the purpose of it is to try and maximize the value that the estate's going to get. Another thing I wanted to talk about, which has come up lately, there was a recent court case, I think it was set in mid-April of 2021, called Breslin v. Breslin. This involves charitable giving issues. And in that particular case, there was some issues that went to mediation, and the charitable parties didn't send any representatives to the mediation. The mediation was resolved. They had an agreement and settlement that was approved by the court. And then the charities looked at it and realized that they were either left out or they were significantly reduced in value. I'm not sure which one it was, but the point is that they were harmed financially in some way, and they were very upset. So Breslin v. Breslin decided, if you don't show up at the mediation and jockey for your position and it goes against you, you have no right to dispute it later. How this comes up is on a recent case I was involved with, there were a number of charities involved, and this was post-Breslin hearing. And so we had 2 assistant attorney generals and 3 charitable attorneys show up who very, very aggressively lobbied for their interests. It's a shocking thing to experience, but the message we have for people is that in estates, trusts, et cetera, when you have charitable giving that's done, you really need to pursue and fulfill those requirements, because if not, they're going to come after you. Another one is a little bit of a one-off, but it's come up a couple of times in the past year or two, is if you have an heir or a beneficiary who is incarcerated, who's in jail or prison somewhere. We have a couple of people who are, one of them is in federal penitentiary, another one is in state prison on death row. There's a group called the California Victims Compensation Board. Now, we talked earlier about notice requirements. This is one of the parties that you have to notice in probate, because if there's any way for that incarcerated person to be a beneficiary heir who gets funds, the Victims Compensation Board has priority over that, so you have to notify them. That's pretty much all I wanted to do, just to bring it back. What I'd like to do is have Grace come up here and we'll start answering questions. Oh, we're going to do it from the table. Perfect. All right. All right. Very good.
Okay, I will start with this first question. Do you have to see a judge even if you have a trust? And the answer is, of course not. You only have to if you need to. So it's hard to say what you're asking, but in general, you don't need to go to the judge. That's what the value of what a trust does, but you can if necessary.
We're trying to do this.
While Ron is getting settled, I'll go through the second one here. What is a revocable and an irrevocable trust? So a revocable trust is one that is revocable during your lifetime. That trust, once you pass, becomes irrevocable. So that you may have heard those two terms. There's also a way to put together an irrevocable trust during your lifetime when you're trying to gift property to other parties that works for you for some interest, usually Medi-Cal or VA trusts or those kind of trusts. There's also special needs, which is sometimes irrevocable.
What is the website for escheated assets? That is the California Secretary of, the California Controller's website. So california.gov, I'm not sure exactly where it is, but it's very, very easy to find. They actually made it easy to find it and easy to collect from it.
Okay, this is a fun one. I've just recently had this challenge. Should personal auto be titled in the trust? Currently, it's titled in my personal name. It's a daily use car, not a high-end specialty or collector car. So I've recently had this happen. Do you realize it is easier to do anything at all in the country than it is to get a car transferred from a living trust to the successor trustee? I used to always say, no, leave the cars out. In your case, your car is not a high-end or specialty valued car. However, someone will have to change the title from you to someone else. And that's the hard part. So make sure that you have someone, that can take that car from you. But one of my clients, and this is something we all do, and a lot of times we do this because we want to keep the memory of our spouse or our family loving member alive. We don't remove our deceased family members from bank accounts or cars. So two people were on this car and we had to have both of them removed. I went back and forth. It took me at least 3 months to get this car out of the DMV and into the trust.
And just to add to that, the real issue for a car, whether it's in trust or not, is the liability for it. The concern that we always have is a person who gets in the car, maybe they're confused, intoxicated, incapacitated some way, and something happens. Either they or a passenger or a person outside the vehicle is injured or killed. So we try not to bring those kinds of liabilities into cases where we can avoid it. Insurance is a critical piece. Also, the value of the asset. The car could be worth a significant amount of money. And so we would often want to get a lien on that and would prevent them from transferring it without having that value come back into the estate or the trust.
Yeah, that was some of the issues we had. Are you going to go?
Okay. What do you do if you have no one that can serve as an executor? Would it be best to do a trust and have that person serve as an executor? So let me clarify the language first. An executor is the person who handles the will. The trustee is the person who handles the trust. For all practical purposes, the kind of things that they do are very similar and in many cases identical. It's really just which document and therefore which assets and liabilities that you're talking about that they're responsible for. To answer the real question, if you have no one to serve, the obvious next step would be find a professional fiduciary or a family friend or somebody that you trust. But again, understand all those things that Grace talked about, the responsibilities that the person has to fulfill. Those are substantial and they're time consuming, and many of them are very technical in nature. And you want to make sure that the person who's doing the job can do all those things, because if they fail to do that, they could be subject to a breach of fiduciary duty claim. And if it's true, the judge can assert what's called a surcharge, which is basically a penalty or a fine for failure to do it. And that's going to be the cost of the harm that was caused to the estate.
That one relates to that.
Can trustee and executor be assigned to the same person? Yes, absolutely. In fact, it's often efficient from a cost point of view for the person to do that. The roles are slightly different. The executor will have more court supervision in most cases. And it may be, as I mentioned, with the limited authority versus the full authority, they may have things that they are unable to do without prior approval. If it's a pour over will, it effectively puts those assets into the trust, and you really just have the trustee doing everything.
Here's another question similar to that. What is a pour over trust? I'm assuming that you might be talking about a pour over will, but if you're talking about a pour over trust, you might be thinking about a testamentary trust or a trust that money is transferred to based on a certain condition. The assets that are included would be whatever the trust says. If you're talking about a pour over will, it's about when something is left out of the trust and it needs to be put into the trust in order to be processed through the trust administration. That it does require a petition. We had something like this happen where financial assets, the RMDs of one of my clients were not transferred into the name of the trust. You would never find it on the statements of the custodian because they're buried in the third or fourth page, and they just put it in his name. So a lot of money was in his name. We had to get a Hagstead petition and transfer that into the trust. You need a good assignment, a good intent language in the trust, and a good general assignment to make sure that that happens. You have to argue to the judge, and as long as you have the intent backup to prove that it was intended to be in the trust, then you usually can succeed. I'm 100% on these so far, but you never know. Do you want to go?
How do you make sure that items in a collection such as art or jewelry are part of your trust? What if it's worth more than $166,250? First off, to make sure that it's part of your trust, we have something called Schedule A. It's just sort of a generic term that we use for a list that often appears at the back of a trust saying what are the trust assets. Unfortunately, most trusts don't have that Schedule A anymore. They're not listed. We have to go through the assets and determine which ones belong to a trust from your state based on the language in the will and the trust. In terms of how do you make sure they're in there, that's when you talk to your attorney and explain to them the assets you want in it. As to whether it's worth more than the $166,250, if it's worth more than that and it's not a trust asset, then you have a probatable asset.
I have another one about real property. If real property is included in a trust, will it be reassessed? Of course, it depends, is always your favorite answer. Generally, no. If it's the grantor putting it into their own revocable living trust, that's not reassessed. There are times when it could be, but if you're asking about transferring it into the trust in general instead of holding it in your name, that would be a no, not reassessed.
So it's a little bit of a story, so try and shortcut
Let's
it.
go over this one first, because this one kind of all goes together. So if one spouse of a family trust dies where both spouses are trustees, does the trust have to be updated? I would always say yes. Anytime you have a situation like that, you need to go see your attorney. There's always a change that you should consider, and you do have to file certain affidavits. So I would go. Does it have to be updated? Again, then it depends on what's going on in your family. But I would see your attorney if any change in a family situation like that happened. The next question is, if I already have a trust established and want to change beneficiaries, can I do that independently, or must I go back to my attorney? Again, huge issue. I would go back to your attorney. Anytime you're going to change beneficiaries, you want to think about who's going to complain about that change. And if one of those beneficiaries would complain, I want to make sure it was done right. Can you do it yourself? I suppose you could if you were really good at figuring out how to express the interest, but that would be something that I would go back to your attorney for. And now we're on this other group of questions, which relates to debts and living trusts.
So just as a follow-up to the comments that Grace was just making about this, the judges in LA County Probate Department are carrying 600 plus cases, and anywhere from 20 to 75, maybe even 100 cases are heard every morning There are 3 or 4 different hearing schedules during that. And most of them are situations where people tried to do things themselves or something was done improperly by somebody who didn't know what they were doing. Just be aware that's why a lot of cases end up in probate. The story here is, as the current executor of an estate, I've been interrogating cold calls from a collection agency telling me they're checking if there's a probate and U.S. Bank has hired them to collect Visa card debt. Assume that means credit card. U.S. Bank's letter said they may use an outside vendor to handle outstanding debts of the estate, but they don't name a specific company. When I called the bank many times, my calls are routed to an unnamed collection company who tells me the bank has no letter for the estate naming a specific collection company. The bank is given authority to collect debt. I refuse to pay any debt collector or third party not named by the bank. So far, it's been weeks of catch-22 round and round. What are my rights? Well, I'm not going to talk about the legal rights, but in terms of the process, you have the ability to accept or reject creditor claims, and there is a process for that. There's a period of time that has to expire if you're rejecting a claim, and once that period is expired, they may or may not be able to object to your objection. Grace could answer the legal rights and remedies.
Well, I mean, if you're an executor of an estate, you basically named it, this is a creditor, but they're an unsecured creditor. What's interesting is U.S. Bank. I think that this is one of the banks that is doing some crazy things right now. I don't remember if it is it USAA or US? That's USAA maybe. I recently had a problem with the USAA bank. But so the other questions on this relate to similar things about trust. In general, so is a typical simple living trust legally obligated to pay all debts of a decedent? As both the executor and the successor trustee, you do have a fiduciary obligation to manage the trust appropriately. Paying debts is one of those issues. But what is a debt? Like Ron was saying, when you're an executor, a creditor will file a creditor's claim, and it's easy to decide what to do. If you have some reason to object, you have the right to reject that creditor's claim. If you don't have a reason, you have to remember that you have this obligation you don't want to lie about what's in the estate, but you can negotiate with them. The second question here is, so in the answer to the first there is, they're not legally obligated to pay all debts of a decedent. But if there is, in most cases, what we want to do is have we want to have the probate estate have zero money in it. We want all the money to be in the trust. So the decedent would, if they had any debts, they would be in the probate estate, which is insolvent basically. But you still can't, the creditor can still reach into the trust to get them paid, but creditors are unsecured. So they're in a different world. So you can negotiate with them. So I recently had this conversation. So the second question is, if an executor feels that a debt is unfairly owed, what are all the devices debt collectors use to collect when they don't have a copy of the living trust? That's an interesting question with all sorts of, I couldn't tell you all the devices that they use, but again, in general, if you feel something is unfairly owed, you can object to that claim. And you're talking about an executor here. So yes, there is a court process for that. You have the right to object those debts. But what was I going to say? So what they generally do is they will not have a copy of the living trust. And recently we spoke about this with my study group that I run on Thursdays. And we talked to somebody on our team talked to a debt collection agency, and they said they will find everything they can find in the decedent's name, but they won't know about a living trust. You would have to disclose that there was one of those. And so they won't know about all those things. So they don't go after them because in general, they usually have spent very little for the debt. If it's one of those things where they bought the debt and they're trying to claim it, they probably paid 6 cents on the dollar. So you can offer them something less than what they were asking for. That's part of negotiation, but you have to be careful to still be a fiduciary to the estate and the court. Tactics, I don't know. Do you know any tactics besides harassing phone calls like item 3 has listed?
Well, the bargaining tactics they're talking about is to avoid making full payment. So that's the executor administrator's bargaining tactics. Mm-hmm. I think you've already answered that question. Okay. You can go and contact the creditor, or you can talk to their agent if it's been sent to a collection agency. and describe the situation. If you don't have enough funds to pay it, that's an obvious answer. But in many cases, there are creditors out there that are willing to negotiate. It's very common, and particularly for credit card companies. They will stake the high ground at a very high number, but they're often have great latitude to reduce that, especially if it's gone to creditors. What Grace was talking to is what they call factoring. You go and buy somebody else's debt, and then you try and collect on it. So you're buying it at substantially less than its face value. Those people have a lot of room to negotiate. When you start running up against where their limits are, they're probably going to tell you, I can't go below, whatever the cents on the dollar it is. But you could bargain as aggressively as you think is appropriate, and anything up to the full amount is the responsibility of the fiduciary. So if you can get less, that's more that you generate for the estate. That's a favorable outcome for the estate. The judge is going to look favorable on the time you spent doing it, if it's reasonable. If the cost to do it is less than the benefit that you obtain for it. There's a question here that I'm not really sure what the direction, so I will read it and then maybe have somebody comment on it. It says, how do you best protect 401k plan from ERISA consequences after one spouse dies? I'm not sure what they're meaning by ERISA consequences or the connection to a spouse dying. So
I'm not really sure
elaborate on
either,
that.
but I would think that the spouse is usually the beneficiary.
Right.
And would be notified by the company about their rights. One more about this debt situation. What are the best bargaining tactics for a living trust to avoid making full debt payoffs? I think we talked about that also. You can look at, in some cases, you look at the amount of cash that you have divided between whoever's there, because if you have real estate, you don't want to necessarily take the real estate and sell it in order to pay debts if you can. Mortgages are obviously secured debts. We're not talking about those. But sometimes too, just paying the debt forgiveness for if the credit card company gives debt forgiveness and you get a 1099, it's actually cheaper sometimes to the estate to pay that debt forgiveness than it is to pay the full debt. And then here's another one that's coming up twice, I think. What are the best living trust provisions to prevent self-dealing by an older brother executor to give protection to a younger brother equal share beneficiary so he doesn't have to go to court to restrain his older brother? I don't know if there are living trust provisions that can describe that particular situation.
I think what they're referring to may be the no contest clause. Does that sound like what they might be thinking about?
Well, we do have no contest clauses, but anything can be petitioned over. The no contest clause is not what most people think anymore in California. So going to court might be the best way to restrain this person from doing what he shouldn't be doing. Getting a lawyer is one way. Writing a demand letter is another way. It's difficult to answer any more about that. But
let me talk about the no contest clause, because that's been drafted into lots of trusts now. The no contest clause, the concept is if you object or cause any problems to the administrator in trying to make the distributions to the proper parties, if you try and assert claims the trust is invalid or that you should be getting more money, those kind of things. The concept is that if you do that, you will lose all your rights to any proceeds in the trust or the estate. You need to think about a no contest clause in the same context as you would about an employment contract. California views those very, very narrowly in scope. There are lots of restrictions that they will consider. And if it's drafted too broadly, it's probably not going to be asserted in the court, or the judge is probably not going to accept the no contest clause. So that they're not as great as we'd like them to be. They've also never been tested, to my knowledge, in an appellate case, which is where you really get the determination that they're effective or not. There's never been a case where that's been the primary factor in the case, but we'd like to see it at some point so that we can know we can rely on these no contest clauses. And the real thing what you're thinking about is, can you persuade this person not to object and cause problems? If the cost of objecting is greater than the benefit they're likely to get. So if they're going to lose everything, if we often suggest that if you're going to make a distribution or a bequest in there, make it big enough that it hurts the person if they don't want to lose it.
Here's something really quick. What happens to frequent flyer miles of the deceased when there's no will in a small estate? This is exactly what I was talking about, digital assets. This is a digital asset that needs to be transferred to another party. Digital account is one of the best ways to do that. It would depend on the frequent flyer rules in this particular case. And how would you find those? Going through the frequent flyer program, which probably changed 1,400 times. Are we almost done?
You have one more?
I do have one. If in mom's trust is a bank account, when dad died, mom did paperwork at trust to make me successor trustee. I also have 2 sisters. Would it be better to move into a non-trust account, list all 3 daughters as beneficiaries? No.
That would be commingling. It would be an improper distribution.
All right, I guess that will have to wrap up our seminar for today. A big round of applause to Ron and Grace for a great presentation. And a big apology again from me. I did a lousy job as timekeeper, and so I cut Ron short at the beginning. But I think we covered a lot of the information. And if we were not able to get to your question, I'll see if we do have a record of those, and I'll see if we can get an answer and get that back to you. So thank you so much for tuning in, for being a part of this. As I mentioned before, the recording will be posted on our website next week, and I will email everyone who registered in advance. I will email all of you with the link to that and when it is available. If you did not pre-register, send me an email. My information is here on the screen, and I will include you in that so that you will also know when it will be posted. But the website is there, torrancememorial.org/news. And then if you click on financial health on the left side, that will bring you to where that recording will be posted. So as I mentioned at the beginning, this is our final seminar for 2021. Really hoping we can start again in person on Saturday mornings in 2022, but we're still working out all the details, and there are still some outstanding guidelines and uncertainty as to what's going to happen with COVID. So stay tuned for more details on that. I will communicate with you as soon as we're able to do that. And so thank you again for your participation, and enjoy the rest of today and the weekend and the rest of the year. We look forward to seeing you in 2022. Thank you.